Welcome back. So we're moving on next, and this time we're looking at the issue of judgment debts. And we're talking about the $170 million judgment debt that Ghana is to pay to Ghana Power Generation Company, which is GPGC, following the outcome of some arbitration proceedings in London. And this is coming from a contract entered into in June 2015 for the production and supply of power. And this has generated a lot of conversation this week, and we shall be looking at the details of this. How did we get here? Also, we will be looking at an interview we had with the Power Minister at the time, 2015, when this contract was entered into, to understand the role he played. He has been talking about the role he played in that transaction. But here are some facts that we need to put into perspective ahead of our conversation. That the contract was initially worth $24.9 million per annum over the contract period of 4 years. And that's bringing it to about $99.6 million US. The government failed to apply and set aside the January 26, 2021 decision of the London-based United Nations Commission on International Trade Law Ancestral Tribunal. And subsequently, there was an extension of time for government to put in a challenge. Now, the contract, exactly, this is the same thing. The contract was initially worth that. Now, out of the total, $134.3 million represents the early termination payment claim. And of that, it's broken down into $69.36 million as early termination fee. And then there's a $58.49 million for mobilization costs, $6.46 million as demobilization cost, and $32,448 as preservation and maintenance costs. The tribunal also awarded $614,353.86 as cost of tribunal and legal fees expended by GPGC, that's a Ghana Power Generation Company, during arbitration of $3 million against Ghana. So this is breaking down the $170 million judgment debt. Rather, government turned up at a London commercial court with two reasons as impediments as to why it couldn't challenge the arbitral award. And the first one being that the country's 2020 presidential and parliamentary elections affected that process, and also that some key officials in the Attorney General's office contracted COVID-19. But obviously, the tribunal didn't pay any mind to these if you like, reasons given for Ghana's inability to file the challenge against the arbitral award. And so we find ourselves where we are at now, currently, where we have to dole out $170 million for GPGC for terminating the power purchase agreement that was entered into in June 2015. Let's take a listen to Dr. Kwabena Donkor, the sector minister at the time of this contract formation, to understand his role in this discussion. The minister back then, Dr. Kwabena Donkor. Let's take a listen to him on this interview.
Minister responsible for the sector, indeed a cabinet minister responsible for the sector, I had a responsibility to ensure the end of load shedding. Load shedding arose out of generation inadequacy, so we needed added generation to, at the minimum, create an equilibrium. But more than create an equilibrium, we also needed sufficient power for the projected growth in the economy. And therefore, yes, I led the negotiation of this particular contract. The minister always takes responsibility. Yes, you form a technical committee. The technical committee comprises people from the Ministry of Power, from ECG, from VRA, from Ministry of Finance, and the Attorney General's Department. But the sector minister takes absolute responsibility because they report to you. Yes, we did that. And we negotiated an agreement that had the lowest tariff of all the emergency power agreements. We negotiated an agreement that had the shortest duration of 4 years of all the emergency power agreements. And we negotiated an agreement that did not need any government of Ghana financial security. And so there was no standby LC, there was no government consent and support agreement, there was no call put option agreement, etc. And I thought that was one of the best agreements in terms of fiscal terms.
Right, so that was the sector minister, Dr. Kwabena Donkor, Minister of Power at the time, when the contract for the power purchase agreement, the contract for the power purchase was signed back in 2015, June 2015, telling us about the fact that he led, the discussion and the transaction and all of that. And so we'll be looking at this situation, which has led us into the $170 million judgment debt we have to pay, and matters arising from that. In the studio with me, we have from my extreme left, Nana Amwesi the Seventh. He is the Executive Director of the Institute for Energy Security. Also, we have Mr. Bobby Banson, a private legal practitioner. And on Zoom, we have Dr. Theo Echampong. Good morning, Doc, on Zoom. It's good to have you.
Morning.
And gentlemen in the studio, it's good to have you too. We're happy. Great. And I hope you're doing well.
As well.
Good. So Doc Echampong is in Scotland as we speak. How is Scotland, Doc?
Good, yes. Summer here.
Right, yeah, it's good to have you. Good. So this news broke earlier on in the year. The arbitral award was given in January 2021. A lot of issues were said around the time. It went underground a bit, and now it's come up, given what has happened in recent times with the government's inability to challenge the arbitral award. And so we're looking at how we got here, what went wrong, what could have been done better, and all of that. Let me start with you, Dr. Theo Echampong. Your initial thoughts on this issue.
Good morning once again. So my initial thought is that it's not surprising, at least to me. And the reason is that we have to go back a couple of years during the height or the midst of the Doomsday crisis to understand some of the decisions that were taken at the time. So the then government procured a lot of power or new capacity, some of which were emergency power agreements. And they had very specific timelines or tight timelines that they were to be met. Right. Some of the projects came on stream, others didn't come on stream. But during the course of the time, we had a new government that was elected into power, and they decided to review some of these contracts that were signed at the time. And they set up like a technical committee to help them in relation to the review. The committee made a number of recommendations that some of the plans or the agreement needed to be cancelled, others needed to be renegotiated, and they put some numbers around that. And then on the basis of that, we had the Minister of Energy write a letter to this particular firm, GPGC, saying that they're going to terminate the agreement because they hadn't met some of the conditions precedent in relation to that. And then, of course, the company challenges that, and they take that to arbitration, and they get, a settlement award, which was in January of this year. But if you look at how those negotiations were done and the letter and spirit around those negotiations, I think it was inevitable that we were going to get to the point where some of the companies would challenge the decision of the government to actually cancel the agreement. It's more so given that the evidence showed that they had actually done, some work on the ground.
Right. Now, you talk about the review process. Looking at the PPA review report, it clearly shows that review actually started from 2016. So under the previous administration, and then it carried its work into the new administration's term, and then the recommendations were made for implementation by the new administration. So on that basis, there's that understanding that at least for the two parties or the two governments, there was an understanding that yes, there was a need to do the review. Is that correct?
Absolutely.
Right.
Absolutely. I mean, the point was that during the period, there was a lot of, or the lack of coordination of the activities of procuring power amongst the different core government agencies. So you look at some of the report, and in one breath, people were negotiating with the ministry. Sometimes they were negotiating with ECG, and then you had other government agencies in there. So by the time someone actually called and said, guys, stop, let's take a look, we had actually over-procured power and over-contracted ourselves on the fiscal front. And yes, the then government then decided, well, let's see how we get out of this. But the process definitely started under the SOR government, and then it continued with the subsequent change of government in 2016.
Very well, thanks. We'll be coming back to you, but let me come to you, Nana Mwesi. So let's move on. So there's that agreement, that consensus, at least from the PPA review reports, that we had, you know, if you like, gone into several contracts for the supply of power to the point where we had an issue with excess capacity, so there was a need to deal with that. Not a bad thing. So let's deal with that. Let's set up a committee, look into it, and give us the necessary advice and recommendations. That was done. Then we have this. GPGC was one of the entities that the committee recommended that its contract be terminated. So then the question is, how should that process have been undertaken in terms of terminating? Because obviously you're looking at a situation where you're terminating, but you're ensuring that you don't get involved in a situation where the losses or the liabilities to be incurred would outweigh the cost that you would necessarily incur if the contract was being made to, or were being made to, you know, travel its course of the 4 years.
Well, Abuna, good morning to your viewers as well, and to yourself. Contracts are made in such a way that from time to time, you are allowed to amend or review it. The lawyers are here, I'm sure they will speak to that, because market conditions change. And when it changes, you want to ensure that it doesn't impact on you negatively. And so you are cushioned. And so the committee was put in place, just look at the issues around it and see how do we escape a possible cost that we call excess capacity, projected excess capacity. Because at the time that they were looking at, they didn't say we had excess capacity installed, but they are looking at if it should be installed and those projects should come online as agreed by the date, then we will have excess capacity vis-a-vis our demand as a country. And so you want to avoid this cost. If you want to avoid costs, you have to approach it in such a way that you don't attract other unnecessary costs. So you are trying to escape from 96 points, close to 100 million cost. But where do we stand today? 170 million. It means that we didn't take a path that was prudent and cautious enough to avoid this cost. Committee have recommended that we should terminate this agreement. Unfortunately, the plant had arrived in the country at the time that the decision was made. This is a person that you have entered into an agreement just like a marriage relationship. And let me use you, Abena. Though I'm married, if I come and say, Abena, I want you to be my wife. So I've gone to your family, presented the first snap and few things as ko. You were getting ready for this marriage. Then I had change of mind. So I am SS. You also SS. It could give us problem. So what I do is my mother says, forget about this marriage. I don't go and write a letter straight to Abena and say, Abena, from today I can't be your girlfriend, boyfriend anymore, and the marriage will not come on. So pack your things and go. I need to come to you, appeal to you, because for every trade, even tomatoes and pepper, when I've contracted you to bring me the pepper and things have changed, market conditions have changed, I will still ask you, the provider of same commodity, that please look at this thing and help me, because you can only be in business when I am in business. So the first place to start from is negotiation, engagement, and say that, help us save this cost. Because if you plant the generator, we can't dispatch it. In the first place, it's going to be even a dent on your reputation that you planted 107 megawatts in Ghana, was never used.
But should that matter in the circumstances where the termination was based on the fact, or at least that from the minister's letter, and the minister at the time, Honorable Jakon, and then the PPA review report at the time, that the allegation is that certain conditions that had to be met were not met. So that irrespective of the fact that you've brought in the plant from Italy and you're yet to set it up, there are certain preconditions that you had to fulfill. They hadn't been done.
Okay.
Then, of course, there was also conditions subsequent to signing. That, too, had not been done. At least that's what government stated.
Okay.
So, are you saying that still in the midst of all those alleged failed performance or non-performance, there should still be that, negotiations to see that we don't necessarily offend the other side, as it were?
But don't you see a clear disparity between what the committee, said? They said we had excess capacity. At a point, they say that the tariffs were high, and so it's going to impact us negatively if we should pursue this. So let's terminate it. This is the recommendation. It's for the minister to accept it or not. But then what we presented and wrote in the letter to the company, GPGC, had nothing to do with excess capacity. It was a different excuse totally. Condition precedent. You were asking this guy to get a license, or this company to get an Energy Commission license. And at the time that you were engaging it, they were writing the termination, they have not gotten the license. Who is Energy Commission? Energy Commission is government. The guy had applied for it. He has made a move for this license. At the time, you had not constituted a board for Energy Commission to be able to execute this on behalf of the guy. So who caused it? That is one. You made an excuse that the guy was siting the plant when he had no permit. Finally came out that the guy has procured permits from the Bonkatamanso Assembly. You see, so the reason that you raised were quite flimsy, something just to push them off. But I'm sure that if you have engaged them properly, some of this could have been avoided.
Right.
That is my position.
Very well. Now, Bobby, let me come to you here. Still on the basis for the termination. And, of course, we have the benefit of the arbitral award, so we can make reference to the findings. Government is talking about certain breached obligations, but it turns out, at least from the arbitral award, the findings there, that there were no such breaches. So if you look at paragraph 475, for instance, it's saying that in addition to such review by the Attorney General of the PPAs in question of the Cabinet Memorandum of 20th June 2017 and the PPA Committee report, the basis of her conclusions is said to be information attributed to the Energy Commission, the absence of a Section 11 Energy Commission Act license, and, quote, established Energy Commission policy. The latter apparently required a contractor to obtain siting and construction permits from the Commission and prohibited the deployment of a used plant. The AG's advice further references the conditions precedent provisions of the EPA, citing Clause 3D in particular. It contained the bold statement that although CPs have not been performed, which is conditions precedents have not been performed, there's also no evidence that the effective date has been extended by mutual agreement by the parties. This is the AG's advice. Now, it goes on to say that that statement is wrong to the extent that there is no provision in Clause 3 of the EPA for the extension of conditions precedent by mutual agreement pursuant to Clause 3C. It is the prerogative of the party not responsible for the fulfillment of a condition precedent to grant an extension. Essentially, so on the bit about extension of, the effective date of the contract and everything, the findings saying that really and truly that's not what it is. So the question then is, on what basis the government proceed with the termination?
Well, we can only make reference to what they put in the termination letter. Now, any person who has studied investor-state arbitration awards, even though it's not stare decisis as we have in common law practice, would be aware that with investor-state award, once the contract states provides for conditions precedents, that must be satisfied by the investor with the licensing of the state entities or state apparatus. The state cannot turn around and say that we have frustrated you, you did not get the license, so we are terminating it. Every single arbitration award in relation to that points to that direction. And if you look at the committee, I looked at the list of members of the committee. It was made up of persons from the Energy Commission. In fact, the executive secretary was the head of the committee. And so the Energy Commission, executive secretary, chairs a committee, does not put anywhere in that report that terminates this particular contract because they have not met the CPs. The only reason they gave, as Nana said, was because of excess capacity. Now somebody turns around and says that, okay, beyond that, I am giving the advice that terminated because they have not met conditions precedent. And I'm worried. I'm worried particularly because we just went to market to borrow 200 million to set up a bank. 200 million to set up a bank. And the judgment debt is not only 170 million. If you add the interest, you add the legal fees, it's in excess of 200 million. So this 200 million, we will pay.
Of course.
We will pay. They will go and attach our assets in South Africa. We will pay. We can use that money to set up another bank. So we go for a loan to pay a debt. Where are we going? It's because we keep talking about judgment debts. The circumstances that, you see, the arbitration panel had a Ghanaian on it. This award was on the merits. People think that arbitration, when an award is delivered, it's easy to go and set aside like a normal court. No. The grounds of setting aside are very, very limited, very, very narrow. I don't know why they thought they could have set it aside. You have participated, you have appointed an arbitrator, you were served with every single notice, hired law firm to represent you. Then when it is delivered, then you want to go and set it aside. On what grounds? I mean, how are you going to set it aside? Because you cannot set an award aside on the merits. You can only set it aside on procedural flaws.
Right.
That there was no arbitration agreement, that the panel was not properly constituted. And there is nothing that has come out so far that suggests that there was a fundamental flaw in the constitution of the panel, the arbitration contract itself, the clause itself, or anything that will form a basis to set aside the award. Now, we ask ourselves who would be held responsible, because we would pay the 170 million plus.
Right.
And we'll be talking about it. If the committee setup said, go and negotiate with them, I saw 24 million over 4 years, or 18 million now. If you add 24 times 4,
24.9, yes, 24.9 million.
it will not come
annum
to 170. So worst case scenario, why didn't we take that approach? That the worst case scenario is 24. So what the committee said, as a layman, not an energy expert, is that if we had allowed the machines to be there over the 4 years, we would have only paid 24 million, let's say 25 times 4, 100 million. If we had not terminated and had allowed it just to be there, we would have paid 100 million maximum.
Right.
And we terminated and we are paying 200 million.
Right.
So we didn't have the benefit of the machine, not even 1 power.
Not at
and
all.
we are paying 200 million almost.
Right. Let me quickly cross to Dr. Theo Champon. Doc, now when you look at let's go into the bit about excess capacity here. The committee report, the executive summary, let me just read a portion of it to you and then we interrogate it. It says that the proposed actions by the committee on the executed PPAs as contained in table 9.2 will reduce the average annual excess capacity from 1,463 megawatts to 46.5 megawatts. And the average annual cost of the excess capacity, which includes estimated cost of termination, from $586 million US dollars to $26.59 million US dollars. And it says that one-time cost of termination is $57 million for 3 PPAs which may be terminated. So it works out to $19 million for each PPA that's to be terminated. At least that's the projection, or was the projection by the committee. So you're looking at an excess capacity of 1,463 megawatts being reduced to 46.5 megawatts, at least by the committee's projection. What do you make of that? Was that realistic?
Yeah, so the problem is not the reduction of the capacity itself, because you have to balance the supply with the demand. And however you slice and dice it, we are just going to have much more supply of electricity than we actually would realistically need, even up to 2025, up to 2028, thereabouts. So something had to be done to match the demand with the supply. The question which your 2 panelists in the studio rightly point out is, how do you go about actually resolving this in a way that it is mutually beneficial for both parties? Because after all, these are contractual agreements and they are binding on both parties. So the government cannot just wake up one morning and say, I am canceling it because somebody hasn't met some condition. And when you interrogate it, you realize that the reason why they didn't meet it is actually because part of government agencies that were meant to do certain things did not do it, right? And things then end up backfiring in a spectacular way. So it comes back really to the point about how you go about renegotiating it. But importantly also, and this is where maybe I think the committee's work needs to be interrogated a little bit further. How did they arrive at those termination costs?
Right.
Because that ultimately fed into the decisions by the minister, in the sense that some of the companies, in this case GPGC, had actually done work, and this was established in the arbitral ruling that, part of which you just read. So how do they arrive at the basis that canceling it is just going to cost 18 million, when in reality they had done a lot more work, than that? And then number 2, the letter by the minister, which now tries to find some legal basis, right, to cancel the contract, because they realize that there's actually no way you can cancel the contract, but they have to find something and hang on that to terminate the contract. And again, you go into arbitration and you read the paragraphs 4, 7, 5 down, and it's very clear that the advice that the AG gave, and subsequently the minister also took, they were all not, factually correct.
Right. We need to take a break at this point. We'll come back shortly to continue with the discussion here. And we're looking at the $170 million judgment debt that has been slapped on Ghana to be paid to the Ghana Power Generation Company, GPGC. When we come back, I'll take a few comments that have come through, and then we'll continue with our panelists. This is the Key Points. Stay with us. We'll be right back. Welcome back. We are still here discussing the $170 million judgment debt slapped on Ghana to be paid to GPGC for early termination of power purchase agreement that was entered into in June 2015. I'll take some few comments that have come through and then we return to the panelists. This one says, good morning, Abna. I wonder how our politicians take decisions. I believe my grandmother wouldn't have abrogated this agreement if she were a politician. And that's Kweku coming in from La Paz. This other one says, in their quest to demonize every transaction of the Mahama administration, they either slept on the job or deliberately orchestrated this judgment debt for their personal gain. After all, they can always pass the buck to the previous government. Abna, why aren't we interested in discussing the very reasons adduced by the government of Ghana lawyers in the arbitration? If excess power was the actual reason we terminated the contract, why didn't the government of Ghana lawyers advance same in the arbitration? This Shaibu Mashoud in Tamale. I will go back to you, Nana Amwesi. Still on the decision to terminate and the basis of the review committee, the PPA review committee, indicating that, for the termination, at the very least, this is how much you're going to pay, or the maximum, 18 million for that. Obviously, it turned out not to be so, which is what Dr. Theo Chambo has raised. But then looking at the termination letter by the minister, it appears certain other reasons were given, and Bobby raised that as well. So when it comes to the issue of who is to be held responsible, and I think at this point, that kind of conversation should be had, because you're looking at the public purse. In as much as, yes, some people will be saying, let's look at how we move forward and all. In dealing with who is to be held responsible, perhaps we can chart our way forward better. What do you make of that moving forward? This is a situation that has come up, 170 million in the energy sector, where not too long ago we're going to look for $500 million from the Millennium Challenge account. And this 170 million represents about 34% of that 500 million. So literally, we are going to spend so much. So it's not child's play at all. In terms of dealing with the situation, Nana Amwesi, let's hear you on that. How do we deal with this?
Abena, to start with, the work of Mr. Ahinkra and his team must be interrogated. They must answer to Ghanaians how they arrive at those conclusions. 18 million as one-time payments turn out not to be right. You made an excuse with excess capacity. And trust me, we have nothing like excess capacity practically on the ground. It's in the books. Because, one, whatever we have as an stock capacity, you don't use that one to just decide that there is excess capacity. You need to go and look for dependable capacity. So let me give you this simple computation. 5,200 megawatts of today's installed capacity. The dependable capacity can only be around 4,800 megawatts. What is our peak demand as a country? 3,300 thereabouts. Okay? Strike that out from this. You get something around 1,500. But then you should have a reserve margin of not less than 18%. So 20%, 18% of 4,800 dependable capacity is about 850. What you have is something around 750 or 800. Any power that is given to GRICO to transmit for ECG and NETCO to distribute, GRICO will not lose less than 4.5% of this power. ECG technically will not lose less than 15% of this power. 20% of this power is going to waste. These are not commercial losses, technical losses. 20% of dependable capacity of 4,800. Another 800 thereabouts. Done. We have nothing like excess capacity.
So when the committee says this, and this is under the findings of the committee, that the committee established that even though capacity additions will be required in the years to come, the scheduled capacity addition from the executed PPAs is in excess of the required economic and sustainable capacity additions, which include a 20% reserve margin. So there's even that reserve margin that is added on, 20%. So you're saying, this statement notwithstanding, you're still standing by the fact that
the excess capacity argument, the finance minister can betray or has betrayed this committee. He was asked in Parliament to present how much we have paid as a country over the past few years as excess capacity charges. The minister presented 3 companies, SemPower, AXA, CarPower, spoke about something in the region of 900 million. Meanwhile, we hear that annually we pay more than $500 million for excess capacity. So we should be speaking around $2 billion plus. We have gone to interrogate this claim of even this 900. Trust me, it is not excess capacity, neither is it idle capacity. These are invoices presented by this company for full work done. And we challenge the minister, both for finance and energy, to present to Ghanaians the capacity utilization records of this company. GRICO has it. The Electricity Market Oversight Panel of Energy Commission should also provide this, so we see how much of power we had in excess to pay for. So, Abuna, if it had basis, I am sure the minister or the AG and the former minister of energy could have been bold enough to use the same excess capacity as an argument. But when it came to writing the letter to GPGC, it was a different excuse altogether.
Right. Dr. Theo Champon, let me come to you. Bobby, I'll be coming to you with this whole thing about judgment debt and how to end it at some point. But back to Dr. Theo Champon here, still on the excess capacity issue. You heard Nana Mwesi here. I'm not sure if you heard him, but what he's suggesting is that the committee's report, essentially the committee's terms of reference was to look at the PPAs that had been signed over the period and look at it within the context of the excess capacity arguments that had been raised and whether or not it was prudent to carry on with that. But he's saying that then comes the minister's letter, which is not necessarily grounding the termination on the issue of excess capacity, but talks about conditions precedent and conditions subsequent and all of that. But the committee specifically talks about the fact and actually makes a finding that there's excess capacity. Let us understand this whole bit about excess capacity. Is it a reality or it's not? As Nana is suggesting that there's nothing really like that.
I'll come to excess capacity in a bit, but I don't think that the government could have actually terminated the contract legally on the basis of excess capacity, because I would struggle to see how that would be argued, and maybe the lawyer can throw a bit more point on that, because if you want to cancel a contract, it's got to be in relation to the terms of that contract and whether I have met those terms or not. So I think the basis of the letter and the cancellation of the contract is in relation to finding things within those terms that the company did or didn't do. And that is sort of within that legal domain. And it would have been very difficult to have terminated a contract on the basis of over procuring power or excess capacity, so to say. So coming back to the excess capacity argument, I think I disagree with Nana just a little bit on that. And the reason really is that the reserve margin numbers are all computed in terms of the demand, right, or the peak demand patterns plus that 20% in there. And at the moment, he pointed out, we have installed, dependable capacity, sorry, not installed, dependable capacity around 4 and 4.5 gigawatts and thereabouts. And the contracts, when you look at them specifically, all of that, for the plants that are not coming on stream or are not being fired based on the merit order, you have to pay that reservation charge, or what is called the capacity charges. So I think it's a reality. The challenge, or what we need to interrogate further, is how big is this, gap? So they talk about 1,500 or so in the committee's report. We need to kind of interrogate it currently with what we're producing, with what is being consumed, how much of that gap really is. But I don't think it's a debate of whether there's excess capacity or not, and whether that then triggers the related charges on the basis of the merit order that they use to provide power to Ghanaians.
Right, now let me push further. Should these contracts have been allowed to run their course, in your opinion?
You know, they say hindsight is always what?
Yes.
2020.
Yeah.
I think the decision to terminate the contract, they didn't have the recourse to the full suite of evidence available to them. And also, in relation to the fact that, it was only going to cost us 18 million, when in reality, the company had actually done, a bit more work. So I think perhaps we were a bit hasty in canceling this contract, and we took a hard line kind of legalistic stand rather than maybe trying to negotiate in a bit more soft manner and find a middle ground. That's where I think the challenge really is, and the blame lies squarely at the Ministry of Energy, because they are the sector ministry responsible for this, and they have to provide answers, on the basis of that, because the minister took the decision on the basis of other advice that was given, but ultimate responsibility has to fall somewhere. In this case, I think it's the Ministry of Energy.
Right, and the Ministry of Energy is manned by human beings. So when it comes down to it, certain names would have to be mentioned at some point to ensure, as to who should bear the brunt of this whole situation. But Bobby, let's look at this. There's a talk about negotiations in terms of, how to even move, this whole contract situation forward. But there are those who are even saying that, yes, at the point where the arbitral award was given, perhaps nothing should have stopped government from pursuing a possibility of settlement after because that is, well, so you've received this arbitral award. There's a possibility, this thing about a challenge to the arbitral award. There are those who are saying that perhaps that was even thrown in there because it was a way to get a discussion about settlement in that space. Do you think it would have saved the situation?
No.
Not at all.
If I was them, I would never. You see, before the award is delivered, the trajectory of an arbitration proceeding, there's the notice of intention to proceed to arbitration. Between that notice and the time the panel is constituted, there is what is called cooling off period, where the parties are expected to explore the possibility of settlement.
So that should have happened.
That should have happened. After the arbitration panel is constituted, the first hearing where the procedural orders are made, the parties, of course, upon the proposal of one of them, has the right to say, we have come here, we have seen the claims, we have filed our respective cases, but we want an opportunity for an out-of-court, a settlement. They may even at that stage constitute the same panel as what the French call amiable, I don't want to use the technical word, but the panel will now sort of mediate a possible settlement. It's allowed. So before you get to the award stage, there are so many opportunities to settle this matter. Now, if the award creditor calls experts, because from there they called experts.
The cost of it all.
Pardon?
The costs of
Yes, they have called experts to come and testify on their behalf. They hired a local law firm to present Ghana's legal position. They've incurred all these costs and they have an award. Then after that, you come and tell them that you want to settle far less than what the award has been. Nobody will take you serious.
Very well. I'll come to you for you to conclude on that. But quickly, Dr. Theo would have to be leaving us very soon. So let me just get back to him. Dr. Theo Champong. So in all of this, what would be your advice, moving forward? How do we handle the situation? Because the committee recommended that 11 of such PPAs should be terminated. And this is what we are seeing with the first termination. They actually recommended, number one, that GPGC's PPA should be terminated. And this is what, we have found ourselves in. So moving forward, what would be your advice?
I think what is clear is that we have to be a bit more careful about how we go about this. There is the legalistic or legalese dimension to it, and then going down the potential arbitration or settlement route. But whatever calculations or numbers that we use to justify, because ultimately it comes down to a cost-benefit analysis. We need to interrogate those numbers, and we need to be sure that they reflect the full suite of whatever services the companies have provided. Because in the technical committee's report, which I've looked at and which you also have, nowhere in the appendices do we see, the basis for arriving at some of those early termination numbers. So it's just a question of us being much more meticulous and being much more careful and trying to see if we can then, arrive at a middle of the ground approach without necessarily having to trigger or go for arbitration and potential settlement. Because in this case, we don't even have a single megawatt of power coming in, but here we are paying 170 plus million when that money could have built several schools and hospitals.
Very well. Now, lastly, before you go, when the Agbeshi-Woyome incident happened, of course, that was the first time, Ghana was introduced to this whole concept about unlawful judgment debts for the first time back then. Subsequently, there was a commission that was set up to look into judgment debt payment for a certain period. And, Justice Appel did a good job. There was a report put out. We all expected that perhaps that would bring about, an end to all these unlawful payments of judgment debts and all. But here we are with this situation where we have to now, by reason of, if you like, an improperly, terminated contract. Unlawfully.
It is what it is. Unlawfully terminated
terminating this agreement. We have ourselves in this situation. How do we, so we didn't learn from anything then? Is that what it's looking like?
I don't think we didn't learn. I think we need more institutional collaboration and coordination. But the point really for me is also that government would always enter into commercial agreements and commercial contracts with people, and even in normal private transactions, disputes, do arise. So the challenge, or what I would say, what we need to do is how to minimize them and how to minimize the payment of judgment debt. But I don't think you can actually erase them entirely, because it's just a fundamental part of human nature that disputes tend and will happen.
Definitely, but when it appears that certain decisions were made based on, if you like, wrong projections, then it raises concern, because you're expecting gatekeepers to, have the interest of the state at heart and all of that. We do understand, yes, that once in a while judgment debts may come up. That's why we have lawful debts and what have you. But when it looks like these kinds, then there's a bit of concern, isn't there?
No, so we demand, my point I'm saying, we demand more accountability for the people, or from the people that we have voted into power to make those decisions for us. I don't blame any private company, GPGC or whatever, for demanding what is rightfully theirs. The ball or the onus lies squarely in the court of those that we have voted into power, and to make certain decisions on our behalf, and to make sure that those decisions that they're making are on the basis of the best available information or facts, to them.
Very well. We'll end it here. Dr. Theo Champong, an economist and a political risk analyst, joining us via Zoom all the way in Scotland. We do appreciate your time, Dr. Theo Champong. Yes, Bobby, rounding up on the settlement issue, definitely a no-no.
Yes, if I were in their shoes, I would not take it, especially when we know that with international award, enforcement can be done anywhere. So wherever Ghana has, even that 200 million, if it has not come for the setting up of the bank, or where we go for Euro bonds, wherever the money will hit the account anywhere in there, or they'll go and take it. So there's no incentive, let me put it that way, to settle. And more importantly, it makes doing business in Ghana less attractive to foreign investors. And this is where we should look at, because almost all the judgment debts involving foreign investors come as a result of change of political hand. And gradually we are getting to that point where any investor who wants to do any major investment in Ghana that would need government participation will not do it 2 years before election.
Right.
They will tell you, let's wait, because of some of these things.
Right. Let me push a bit there. You see, I think the general sentiment out there is that, oh, we're going to give these people 170 million for doing nothing. For doing nothing. So then it would seem as though we have done them a favor by terminating this contract and activating a certain provision in the contract, which is to their benefit. But from what you're saying, they have done something, some investment, but by reason of this, they now have had to suffer some losses.
Yes. That is why they called
the impression out there, which is that they are being paid this 170 million for doing absolutely nothing, is not necessarily the case.
It's not It's not that, because part of the award would involve not only the actual cost they have incurred, the expected profits if the investment had gone its lifespan. So that is why they called experts to determine some of these things. So it's not as if they just signed a contract and they were sitting home and we terminated and they've gotten 170
but that's
million.
No, out there as well, because it's like you're giving these people 170 million for absolutely nothing. Yes, they didn't generate 1 megawatt of power
because
or whatever.
We didn't allow
them
to.
But that doesn't mean they didn't put money.
They would have, because the evidence was adduced. They obtained permits. They cited their equipment and were ready to do that. Probably would have dedicated resources, both financial and human, to do this. Then out of the blue, without justification, you terminate it.
They had reasonable expectations.
Investment awards have collapsed countries such as Argentina.
Sure.
Maduro's country, Venezuela. They have lost huge. Their whole economy have been crippled because of investment awards. $170 million, excluding cost and interest, is no joke.
Definitely.
It's no joke. And we sit here, year in, year out, we discuss it. We do it to our own people, we do it to foreigners. And it is because the politicians and the civil servants or public servants who actually call the shots wrongly do not go punished.
Exactly. So that's
we don't surcharge them. I mean, I asked myself, how many people are you going to surcharge for 170 million? Oh, they are not going to get the money to pay. But if we put one person in jail for unlawfully acting like this, it will let people sit up. It's as simple as that. It's as simple as that. We may not get the 170 million back, but if an apolitical investigation is done, devoid of any political coloring, it is said that maybe X-person from Party A, when they were in government, initiated the process that has brought us here without any legal basis. X-person from Party B, when they are in government, had an opportunity to stop it, did not stop it, also continued the rot. We will put person A, person B from different political parties, put them before a court of competent jurisdiction, have a dispassionate trial, jail them if they are found guilty. It will put people in check.
Yeah.
We are in this country when money for only $40,000 got lost, sent with a minister. He even offered to refund the money. The president said no, put him in jail.
Yeah.
It set people down. I think we are taking steps, but I have said before on this platform that for me, we should put as part of our laws, just as international business transactions are not executed without parliamentary approval, the same contracts cannot be terminated by ministers or civil servants without parliamentary approval. It doesn't make sense to me. You have 200 and how many parliamentarians do you have?
75.
Well, I see. 275 persons approving an agreement, majority of them. Then one person with the stroke of a pen will terminate it.
Right.
And then we will all even get to know that most of us will not know that it has been terminated until arbitral proceedings are commenced. And the person who terminated it, because he was acting in his office as a minister, you cannot attack him personally unless you're able to show that he had malicious intention or he knew or ought to have known something. And parliamentarians are sitting there, they can't do anything about it. Meanwhile, they are the representatives of our people. 170 million will be paid by all of us, Wabna.
Oh yeah, we're definitely going to pay.
We are all going to pay. So how come our representatives in parliament will not have a right to determine whether we should even pay or not?
Right.
So put the decision before parliament. Let them debate it. If they think that it is in the best interest of Ghana to terminate it, let them terminate. Then we all know that the people we voted there said we should terminate. But you can't sit in your office as a minister and then with a pen terminate such an agreement.
But there's much to be said also about the role of Parliament as well in approving some agreements and the consequences thereafter. That too, not to say that they necessarily have done a yeoman's job as far as the history.
Well, it's the lesser of the two evils.
Yeah, exactly.
I mean, it's the lesser of the two evils. We voted them there to make mistakes as well.
Very well.
So
let me take some messages coming through, and then Nana, we'll take a break. When we come back, I'll come to you. This one says, oh, Amagana, we went to borrow 200 million to establish a new bank while we're going to pay over $170 million for something we never benefited from. When are we going to stop paying judgment debts? NAPCO guys who are paid 700 Ghana cedis a month have not been paid for some months now, yet we are forced to pay over $170 million as judgment debts. Will anyone be held accountable and punished? That's a Siedu Commenda. This one says, good morning, Abnam Sylvester Nyame. I can't imagine the AG saying they're going to probe those who signed the contract, forgetting the flimsy excuse by his government to terminate the contract. Someone must be held responsible for this debt. Oh, my country, Ghana, he exclaims. From Iliasu in Tamale, he says, what motivated the decision of government officials at the time to append their signatures on take or pay agreements? Was the agreement written in a language they possibly didn't understand? We raised eyebrows at that time about those emergency power agreements. Government at the time was adamant as they were desperate and bereft of ideas as to how to curb Dumso, coupled with the fear of losing elections. The Mahama government posted about how we had excess capacity, not knowing that such excess capacity was a cost to the taxpayer. If Ghana were their private companies, would they go into such agreements? Some persons must be held accountable for their stewardship. I'll take the two last ones here. This says, this is what happens when everything is looked with the lens of politics. Is Godfrey Dame not among lawyers who represented the state? If it is excess capacity, why is that not included in the letter? The English firm backed out because they knew it was a bad case. Godfrey Dame and his boss, Gloria Kufo, should know that they have caused financial loss to the state, hence have to be punished. That's Eric from Ho. And the last one coming from Rex in Accra says, the spinning is being done to exonerate someone from the sloppiness of handling the arbitration case. Quite a number of comments coming through. We appreciate that. Please keep sending them through. We'll take a break here. When we come back, we will continue with the discussions here. Nana Mwesi will have his take on other angles of this issue. See you shortly. Welcome back. You're still watching and listening to the Keypoints. We're live on TV3, also live on 3FM 92.7 and online at 3news.com. Also on our Facebook page, TV3 Ghana. So we're looking at the $170 million judgment debt slapped on Ghana to be paid to GPGC for unlawful termination of a power purchase agreement that was entered into in 2015. And in the studio, we have Nana Mwesi the 7th, Executive Director, Institute for Energy Studies, and lawyer, Energy Security, sorry, and lawyer Bobby Banson, a private legal practitioner. We're having that conversation. Nana, let me come to you. We have just about 10 minutes to wrap up. Let's do the way forward issues, concluding remarks, among others.
Well, Abna will reiterate my point that the Energy Commission or GRICO should publish the capacity utilization records for Ghanaians to ascertain whether there is excess capacity that we are paying for or not and how much. That's very important. But look, every officer, whether public or private, you are, as part of your job and responsibility, is what we call accountability. Mm-hmm. You need to account for what you do, both the good and the bad. For this very contract that we terminated, that has brought us this far, we all know that money is gone down the drain. And so you and I will have to cough additional taxes, levies, and all kinds of things to generate more revenue for government to take care of us, the health sector, and all the sectors. I want to start from when we contracted this company, GPGC. Let's start from there. let's ask questions, the officers in charge. What was the rationale for contracting this? And the basis for contracting the company, was it justified? Can they justify it today? It's very important that we look at that. The review process tells me that both past and present government understood and accepted that there's something wrong somewhere. Good. It's for that reason that they went to look at the nitty-gritties and see a way out to save us cost. Since this news broke, no member of this committee has spoken. That's why I will still call on Mr. Hinkra and his team to also tell Ghanaians and account to us the basis that they used to make that
The early termination payment of 18 million.
That's recommendation to government to terminate. Excess capacity, the amount we stand to pay if it existed and if we abrogated and all that. They need to come clean on that. Many a times we want to target the politicians, but you and I also have questions to give. The technocrats in there have questions to provide as well. Then when it came to termination, an officer in charge of the entire sector, today we say that he followed instruction from cabinet. He would have disobeyed it if he had not followed it. And so he can be blamed. He can be questioned. We are not saying blaming, question him. Because for God's sake, the cabinet in there is made up of a lot of people who don't have background of energy.
So they forwarded the matter to the AG for advice, then the advice was given by the AG, and then upon that basis,
he acted as the chief officer of the sector who understand how some of these things work. We went ahead terminating it. This way it's brought us. Okay, so question needs to be answered there. Then when we got to the arbitration proper, did we do a good job? If we did a good job, I'm sure we'll have gotten some savings. Did we sleep on the job or not? For me, I see pure negligence in there as well. Somebody chose not to act. And even if he was acting, not in the best interest of the state. So let's look at the 4 streams: contracting period, the review period, work done by the commission, the termination of this by the minister, and also the AG department need to speak to Ghanaians on their work.
Very well. Now, Bobby, quickly, on the bit about the arbitration process and people sleeping on their jobs, do you think, looking at the facts and the findings of the commission, could this have gone any other way else? Not in terms of the quantum, but the finding that, yes.
Oh, no. I don't think that the evidence that they have made reference to in the award, like I keep saying, Ghana appointed an arbitrator to the 3-member panel, and he's a Ghanaian. If the evidence, and this was not a default, something like Ghana did not show up, so automatically the tribunal accepted whatever. They went through a trial process, looked at the evidence, possibly did hot stabbing or cross-examined the parties, went through a process, were satisfied that the evidence adduced was legitimate.
The AG says there was a virtual trial, so they had
they participated.
Yes, a whole week.
Yes, they participated. So it's not as if somebody would say, we don't think the evidence adduced was not proper. That is why it's difficult to set aside an arbitral award on the merits.
Sure.
Because you have an opportunity to do whatever you would want to do to discredit the evidence. So I don't think that they could have done any other way. And that is what makes it more interesting. Because when the evidence is presented to you, you know that this is the end result. So why do you wait to get there? Meet the people, have discussions. Because I heard that the tribunal requested that the commission's report be sent.
It was actually a part of it. It was tendered in
Yes,
evidence.
that's what I'm saying. That originally, the termination letter stated we are terminating for you not satisfying the conditions precedent. The report that should have been the basis of the termination stated excess capacity. So internally, there were discrepancies. So it goes to show that you just wanted to hold on to something to terminate it without any lawful basis. And so, I mean, it would have been surprising if it didn't go this way. But whether we could have avoided it is something that I think that, yes, definitely, at least not that if technically it is concluded that we should terminate it, the cost-benefit analysis would be there. If we agree that, okay, we are terminating it now, engage the people. Perhaps we don't need it now, but you can leave your equipment here. We can pay. Whenever we need something, we will re-engage their investors.
Sure.
They would want to continue doing business in Ghana.
Exactly.
Instead of just going to sleep, possibly, and I'm not saying it's right, possibly because they were engaged by another government.
Well,
and if you listen to the discourse...
Quick take on this. The AG says he's going to report, or forward, names to the CID.
Now?
Yes.
Is it now that he's going to report? I mean, sorry, I almost said something, but...
You don't have to exercise restraint.
No, not like a harsh word, but it doesn't make sense that from the time the notice to arbitrate was served, from the time that you started going through the proceedings, you ought to have known that somebody must have done something wrong. Why didn't you report the person from the beginning? Why are you waiting till the whole Ghana is asking questions?
Or even at the point of the review, that whole time when you came...
You could have asked the questions at that time. It's now it goes to show that there may be political coloring on it.
Very well.
Because the person you say you are going to report is somebody on the other side.
Thank you very much. Let me say a big thank you to Nana Amwesi VII, Executive Director of Institute for Energy Security, lawyer Bobby Banton, private legal practitioner, and Dr. Theo Echampong, who joined us via Zoom from Scotland. We had this conversation here. So, as usual, this is where we bring the conversation to an end. It has been an exciting time, and we do hope you had an exciting time as well. We'll be back here same time next week. Until then, stay safe. COVID-19 is real. And go through the protocols. It will save your lives. See you next week. Bye-bye.